Hi everybody, welcome to our second Center in the Legal Profession speaker series for this school year. So excited to see some familiar faces and to have you back. I'm very excited to have Chuck Senatore here with us today. You will be amazed to know how many careers he's had. I'm sure you've read his bio. There are so many, I can't keep track of them. He has worked for the U.S. Attorney's Office. He has been a law firm partner. He's been a director at the SEC. He's been the head of compliance and regulation and regulatory affairs at various banks, including Merrill Lynch and Fidelity. And right now, he plays a role involved in strategy and regulation at Fidelity. And he's had a wealth of experience in both lawyering and understanding what it means to be a professional and in the growth in the compliance field. And he's also an adjunct professor. He's taught many times at the University of Chicago Law School, his alma mater. And we welcome him here today to learn from him. Thank you so much.
Thank you, thank you. So a couple of years ago, I was asked to take on a compliance role in an earlier firm, and I remember the early days of this. And so I was invited to attend, not enthusiastically actually, but I was invited to attend a business convention of salespeople. So I'm trying to meet and greet people, and I'm walking through the room, and I see a bunch of guys like standing over here, and I figure, okay, let me go introduce myself. So I walk into the group, they're chatting, they got their drinks, they're just enjoying themselves and sort of talking about work, talking about their life. And so I said, hey, my name's Chuck Senatore. I go, what do you do? He says, oh, I'm the manager of this, and I have this region, and we're doing this in sales and all this kind of stuff. And talk. And they go, well, so Chuck, what do you do? He said, I run compliance. Conversation stopped. So I just said, guys, relax. I have something that's going to help you. I have here in my pocket, I have a string of garlic. I have a silver steak. I have anything that you can use to try to get rid of the evil spirits, so nothing's going to be a problem. So, of course, the story is a little bit funny, but there's a little bit of a tension between compliance and the business, because in some uninformed places, sometimes people see compliance as something that gets in the way of business. So what I want to sort of talk about today is compliance has become certainly a lot more important, and we'll go over why that's happened. And it's become a lot bigger force in the marketplace, and we'll go over why that happened. But at the end of the day, the easy part is knowing the law. The easy part is knowing the rules and just knowing process and how to do stuff. That's the easy part. The hard part is what I call the art. And it's kind of like, maybe it's a stretched analogy, but it's kind of like learning Kung Fu. There's this element of like being able to sort of deal with a lot of different elements of complexity in an organization, understanding people's motivations, understanding their interests, understanding the regulators is this whole piece, particularly when you're in a position in a firm where you don't run the place. So to give you an idea of how it can be sort of a difficult thing to navigate, I'm going to sort of tell you a true story ripped from the headlines. So real story. So there's a company called SFX Financial Advisory Corporation. They're an investment advisor in Delaware. They had a big producer, a guy that had a lot of clients by the name of Brian Orand. And unbeknownst to the good folks at SFX, Brian Orand, during a 5-year period between 2006 and 2011, misappropriated, stole about $700,000 from his clients. Now, of course, the firm had normal supervisory systems. They had Brian around had a manager. There were things they needed to do to supervise him. They had policies and procedures around how do you avoid things like misappropriation, because certainly it's foreseeable that that could happen. So they had all that. At the end of this, how this got discovered was in 2011, enter the compliance officer, a guy named Eugene Mason. Here comes the hero, here comes the white hat. So Eugene Mason comes riding in. He had gotten a phone call from a client. How come my credit card got dishonored? So he starts looking into it, starts peeling away the onion. One thing leads to another. They uncover the misappropriation. He orders an internal investigation. They pull out all the stops. They bring in lawyers. They get to the bottom of things. At the end of the day, not only does the firm with Mr. Mason in the lead see that he gets terminated, but he is reported to the criminal authorities. So, show of hands, who thought Mr. Mason was the hero and did a great thing? Anybody think he wasn't? Well, certainly you expect that kind of thing, but oddly enough, the SEC sued Mr. Mason. What did he do? I mean, I can imagine Mr. Mason. It's like, I found it. I acted quickly. I was able to determine what went wrong. I reported it. We did all this stuff. He says, well, those policies and procedures that you had, they weren't as tight as they really could have been. And therefore, we're going to find that you guys failed to implement policies and procedures required by, there's a rule under the Investment Advisors Act, the compliance rule, and they sued him for causing the firm's violation. They sued him. So, at least for me, you kind of figure, geez, no good deed goes unpunished, right? But look, that sort of raises the question about how do you navigate this? And so the analogy about the rapids. So my plan today is I may be here before someone, or maybe all of you, will become a future CEO, a future general counsel, a future chair of a board. So I'm talking to you sort of like thinking of yourself somewhere in the future in terms of being in a position to oversee a program. So I want to sort of hopefully give you an early look into what I consider the art. Hopefully, at the end of the day, today's discussion will help you be more effective when you get there. Now, the fact of the matter is, you can tell from the fact that the SEC thought they needed to sort of lay out this issue versus Mr. Mason, is that compliance has become more and more and more and more important. It sort of began some time ago. So back in the early 90s, just recently after the laws and the Sentencing Commission created sentencing guidelines so that companies could take steps to mitigate their risk, or defendants could take steps to mitigate their risk to sort of get rid of sentencing disparity. There was an element in those guidelines that basically said, look, if you have an effective compliance and ethics program, you might get credit. You might have your punishment mitigated. In fact, you may escape liability altogether. A very, very powerful, very powerful thing. Similarly, just shortly after that, the Delaware courts recognized an obligation for boards of directors to be able to oversee compliance in a case called Caremark. Fast forward into the next 10-year period between 2000 and 2010, in a very, very short period of time, in the wake of a scandal that engulfed the mutual fund industry. All of a sudden you had, within 3 years, you had new rules for compliance in the investment advisory space, new rules for compliance in the mutual fund space, or the investment company space as it's known, and new rules requiring compliance programs and broker-dealers, like the Merrill Lynches of the world that sort of sell securities to the public. So it became more important there, and there were rules around it. At the end of the day, that's resulted in good news for anybody that's looking for a job. Compliance has become a very, very hot thing. It certainly continues to be hot because it's something that's become important. People that are in the job, this is unlike years ago, now all of a sudden find themselves in the C-suite with everybody that's running the businesses. I mean, it's really become seen as an important part of corporate America, whether it's a large company or a small one. But the downside is that these are not easy roles to navigate, as poor Mr. Mason learned. If something goes wrong, someone's going to ask, where were you? How come you didn't find this? Now, of course, this is an interesting thing because, as we'll talk about in a few minutes, the compliance officer doesn't run the business. Management does. So there's a saying that success has many fathers, but failure is an orphan. So when something goes wrong, right, you get this. So the point is that you may be asked, where were you? And regulators may ask, where were you? In fact, for poor Mr. Mason, regulators asked, where were you in terms of implementing these policies and procedures, and where were you in terms of making sure they were sort of up to snuff? So that's something you'd have to deal with. And you have an increasingly challenging regulatory environment. I mean, just out of headlines in the last year or so, the SEC has begun to focus more on smaller, less key issues, sort of like borrowing from the New York City Police Department's broken windows philosophy. If you sort of deal with small issues, then you'll promote law-abiding behavior. Just within the last week or two, Sally Yates from the Deputy Attorney General talked about how they're going to be going after individuals more. State regulators, the New York Department of Banking, in a case basically involving BNP Paribas, one of the things was as a condition of settlement, they told BNP Paribas to fire their compliance officer. And their calls to holding gatekeepers accountable. So the issue here is, geez, then how can you sort of avoid all this? I guess and the answer is, you have to plan for the fact that a regulator might substitute its judgment for yours, but once we get into the whole art thing, you at least can be able to provide some degree of a framework to kind of hold that off. And they're also not easy roles to navigate internally. As kind of my little story about me walking into that group of sales guys at one of my earlier jobs, people don't necessarily embrace compliance people. It's kind of like, it's kind of like having the cop show up at the frat party. It's a downer. But the point is that you still need to be able to operate within the business. So look, it's hard enough to be onboarded into a company, even if you're an executive without the challenges of a compliance officer. Korn Ferry tells us that 50% of all executive hires within the first 18 months have problems with fit and leave. That's half of every single hire. That certainly is a problem for corporate America. But you can see that these soft skills are important if you want to thrive and survive. Compliance is not necessarily a profit center. You sort of have to earn your place at the table. Firms have, particularly large ones, have multiple business lines, like my own at Fidelity. We're a far-flung organization, over 40,000 people globally. We have 11 investment advisors, 5 broker-dealers. We have a trust company. We have an insurance company. You get an idea of how many different individual businesses there are that you sort of have to say grace over and have an understanding of. And business moves at the speed of light. And sometimes compliance in some firms is not necessarily naturally a part of that process. So it's really hard to get to know everything, but again, you sort of have to figure out the art. Before you guys decide I never want to even think about working on compliance, I want to tell you actually the positive. The positive is that these are really satisfying jobs. If you want to have a job where the company's looking to you for your advice and guidance, where you need to be able not just to master laws and rules, but you need to develop a sense of business savvy, a sense of understanding political dynamics, a sense of understanding the different interests, understanding how to sort of deal with outside stakeholders, and sort of pull that all together in one job. This job's for you. It can be very, very rewarding. All right, so I guess I've set this up long enough. So I guess with this in mind, what is it that you really, really, really need to know to oversee a program, run one, counsel one? Assuming, again, we're looking into the future for all of you. So with apologies to Stephen Colbert's late night TV predecessor, David Letterman, here's my top 10. Drum roll, please. Are you ready? Okay. Anticipation is built. Role clarity. This sounds very banal, but this is really a key. And so why is role clarity important? people need to know within the firm and outside the firm what compliance is and what it isn't. There's often confusion because, and sometimes self-inflicted actually, depending on compliance officers taking on business roles, about the proper role of the compliance officer. Emblazon this in your mind if you get anywhere near this field as a counselor or a principal. Compliance officers don't run the business. Management does. It's management's job to make sure that the business follows the law. It's management's job to make sure that policies and procedures are in place, that the business objectives are realized. It's management's job to do all this and sort of stay free of controversy, reputational damage, and issue. It's not the compliance officer's job. So then you might say, well, you just said that compliance officers now made it to the C-suite. So what's their reason for being? Why are they there? Why are they adding any value? If management has all that obligation, what do you do? And I'll answer you, great question. Compliance really is a support role. There's this distinction, if you get into sort of management principles, there's line and staff. Line runs the business, staff supports it. So compliance is really more of a staff role. So what does it do? First thing it does is it helps identify the applicable laws and standards. That's the subject matter expertise part. It helps train and communicate, through helping the businesses figure out to communicate it in writing, whether it's a policy or orally through training and all that kind of stuff, so people understand what they're doing. Once those standards are clear and implemented by the business, compliance sort of takes a role where they monitor and test what's happening so that they can give feedback back to management in terms of how well things are going. Because again, the ultimate objective, the ultimate obligation is with management. A compliance officer cannot hire and fire anybody. Only management can. And so the idea is that they give feedback to management so they can do their job. So when you think about, when you sort of go back to Mr. Mason, or in cases like that, I always question, where was management? So if someone were to say, have something go wrong in a firm and turn to me and go, hey, you run compliance, where were you? And I would say, you have tens of thousands of people, you have all the resources in the world. I only see snippets of what happens in the firm. You see everything, I see pieces. So I guess my question really is, where were you? So that's the first thing to think about, what compliance is and what it isn't. There's a whole other thing that we can do for a different day involving, we have a whole series of different control groups that work in a firm. By control group, it's a group that sort of does that kind of feedback and overseeing. You have risk management, you have compliance, you have corporate audit, which is like an internal group that looks at processes to make sure the controls are working. And sometimes they bump into one another, but that's something for another day. But one thing, when you get down the road where you're in the C-suite, when you have functions like that, it's okay if they overlap, you just don't want gaps. Good so far? All right. The next one, focus on the right priorities. So, what are your high priority issues? So if you have a firm where you have like 40-something thousand plus of your closest friends doing things and businesses far-flung all over the world, so what do you focus on? You can't do everything, right? You can't focus on everything. If you focus on everything, one argues that you really haven't prioritized or focused on anything, right? So what do? You can't boil the ocean, and you have to pick the things that are right. You want to go for the jugular, not the capillaries. What's going to hurt you? What's going to be important to you? What could be on the front page of the Wall Street Journal? What's going to basically cause an incredible embarrassment that, even if it isn't necessarily a legal problem, causes shareholders and others to sort of flee from you. A quick story from the mutual fund scandal I alluded to earlier. There's a firm here in Boston that was probably one of the prominent firms in the country. They had a good $250-something billion of assets under management. After a scandal involving market timing and late trading, that sort of was the genesis of the compliance rules, to quote an old third-party presidential candidate, Ross Perot, back in the early 90s, there was this giant sucking sound as assets left that firm. Since financial services in particular is based on trust, the securities laws are based upon the concept of other people's money. So who's going to stick with you? So you have to look for those things that could really kind of be important. They're going to be important to regulators. They're going to be important to your customers. So what do you do? How does that work? So you think, geez, where could I be the weakest? Where are the stakes highest? What do regulators care most about? So the thing to do in terms of getting there is engage your stakeholders. We'll talk a little bit about information flows in a bit. You scan the regulatory landscape. You match it up against your business capabilities. You need to be proactive, and then you sort of pull something together to focus your program in terms of focusing on the right things. And therefore, while something could go wrong, if something does go wrong, it's something that might be sort of along the lines of breakage, because as they say, stuff happens. And when stuff happens, you want it to be minor, not something that's major. Okay, third thing, structure the program for success. Organizations are complex, even small ones. Organizations are complex. So I know there's some sort of suggestion that sports analogies aren't the greatest, but I can't help but seeing all these T-shirts around Boston, about Patriots, do your job. Anybody seen those T-shirts? Do your job. So I guess to use the football analogy, if one person doesn't make the right block, everything falls apart, right? You're going to have all sorts of bad outcomes in terms of the football game. But it's very, very similar in terms of setting up a compliance program, even at a large firm or a small firm. So a couple of tips as to how to think about this, to do your job. So I think of complex organizations sort of like the federal government. So think about it in terms of having this overview, kind of like the federal government. So that's sort of analogous to what you think of like a corporate-wide compliance group. What applies across the board to everybody? Sort of like, you have individual business units, which is the second piece, which kind of could be like the states, because they're sort of insular. They're things that apply just to them and not necessarily the whole business. And you add another wrinkle if you have regions in other parts of the world. That's sort of another wrinkle. It's sort of like they're sort of like their own special insulated entity that still needs to be conducted, can sort of pull together in a federated whole. So how do you deal with that? Well, the corporate groups, you want them to sort of focus on stuff that goes across the enterprise. Things like, in my case, anti-money laundering, employee conduct, ethics. Everybody has to be ethical. Everybody has certain things they need to do. Anti-corruption, no one's allowed to do that, right? So it sort of goes across the board, and those are administered out of a central group. Then you have individual businesses. So like I said, we have 5 broker-dealers. So each of them are individual. They have their own individual issues. You want your compliance people close to their management, feeling accountable and being able to sort of drive their individual issues. And when it comes to, let's say, areas in other countries, you want to have people that are sort of on the ground. So if you have a business in Japan, would you want to manage that from Boston? Or do you want to make sure that you have people on the ground that actually know the Japanese regulators, that actually know the issues over there? Because they will know it better than you do. So structure your program in position so people can, quote, do their job and have a successful outcome. Clarity of expectations and execution of the program. So expectations and excellence and execution. Simple principle here. People need to know what's expected of them. If there's confusion, there's at best inefficiencies, at worst a breakdown. So what's involved? Not rocket science here. Make sure policies and procedures are clear, people understand them, that they're trained to them, and that they know what they need to do. Make them easily followed. Strive for efficiency, simplicity, and transparency, because frankly, one of the best ways for you to get sideways with the regulator is to have a policy and procedure on paper that's not being followed. Exhibit A for regulatory problem. So make sure there's clarity around that, and make sure your monitoring and testing is effective. Foster interconnection. They say information is power. We talked about far-flung organizations. You can't do the job without information. So you need to be able to find ways to pull information from the business. So no one likes sharing bad news. It's a part of the human condition, but you need to find ways to make sure you're seeing snippets of the information that are being generated by those businesses and that they're being sort of rolled up. And so you need interconnection. So there's nothing like being present as opposed to being remote. And one of the things, if you would have noticed this in the last year or two, JP Morgan entered into a deferred prosecution agreement with the federal government over the Madoff affair. The wrinkle that caused the exposure, they had a unit in London that became suspicious of Madoff and filed a suspicious report with the UK money laundering regulators. And they never told the US, and so the US never did it. That whole criminal episode, that dance with criminal liability, arose out of an interconnection failure. So interconnection's really, really important. Credibility and access to management. You can't be effective if you're not trusted by the business. So as I mentioned, compliance and business are sometimes not sort of natural bedfellows. You know, as my story at the beginning of the talk suggested, you must be at the table. You need to understand the business. You need to be able to have engagement in real time as to where it's going, because if the business goes down the road and at the last minute sort of brings something to your attention and you have to undo it, imagine if you're like building a house. Wouldn't it be easier to sort of change the plans while you're talking to the architect as opposed to having to rip down a wall and rewire it after the house is up? Same principle. You also need credibility. And what do I mean by that? It's easy to say no. It takes courage and creativity to say yes. Find a way to get to yes when you're talking to your business partners. Exhaust the different ways that you can possibly look through structuring something. And if you can take every effort to get to yes, and you can't, if no's the answer, you earn the respect of your business partner because they realize that you were trying to sort of help them enable what they want to do in the business that they're trying to do. I actually, at one time in my career, told somebody they couldn't do something and they thanked me. Why is that? It says, well, the conversation went something like this. Well, we could try this. Well, I don't know about that. Well, what about that? We can try this. Well, we can actually structure this a little bit differently. What about this? No, he says, well, I'm out of ideas. He says, well, okay, then we can't do it. Great, I agree. Engagement with the audit committee and board. These are natural partners because they oversee the enterprise. They have their own obligations, and you're seeing actually a little bit of an increase, particularly in the SEC, with the SEC, and this happened in the mutual fund space, of directors actually being held personally liable for breakdowns in compliance issues. So you have a natural partner there. So what's the trick? Again, be able to get to the point, pull together meaningful information from those information troves that you're looking at that I talked about earlier. Sometimes you only have a few minutes on a busy agenda, so you have to be able to sort of get that quickly. Tell them straight what the problems are, don't sugarcoat them, and explain what you expect to do in terms of trying to fix whatever the issues are. Build their trust. They're looking to you. And this could be important if you ever have to raise anything above the heads of your bosses. Handle problems courageously and deftly. You need to become the master of the art of the difficult conversation. Because sometimes you're going to have a conversation with someone, sometimes very senior, that wants to do something, and you got to tell them you can't. So how do you do that? Look, even great organizations have challenging and outsized personalities. So at least for me, the way to do it is to kind of get it to a place where it's their decision. So as opposed to just saying, look, you can't do that, try something like, well, these are the headwinds that, these are the difficulties that you'll be sort of putting us into if you do X, Y, or Z. These are the exposures that we might have. And do you really want to have that conversation with the CEO? I'm happy to arrange it. Chuck, I think maybe I get the phone call back and, maybe we'll do it your way. So you know what? Great idea. Okay. Regulatory relationships and outreach. One thing that's sort of, and I know many lawyers, particularly those that are litigators, sort of need to learn this. I was a trial lawyer for a long period of time, and I've had my share of Donnybrooks with civil litigants where you're fighting over depositions, fighting over documents, fighting over periods, fighting over just for the sake of fighting. You just sometimes do it, right? You can't do that with a regulator. And the reason is, when you think about your role as a compliance officer, what are you really trying to do? When you break it down to its essence, a compliance officer, someone in compliance, has a very similar mission to that of a regulator, don't you think? Very, very similar. Whether it's the context of a firm, if you're in compliance, or a government agency like the SEC, you're both, and certainly in the case of financial services, and this analogy applies in other contexts, I would assume, you are driving principles of investor protection. You're driving principles of integrity in the marketplace. Now, hopefully your firm's values align with that, but you sort of are in the same place. And that sort of makes sense, because if you look at the securities laws, they're set up that way in a way to enable this. So in the Exchange Act and in the Investment Advisors Act, they have this notion of supervisory liability. It's sort of unique. It's not really statutorily in many other places, as far as I know. But there's a reason for it. And the reason is that there are only so many SEC examiners. There are only so many FINRA broker-dealer examiners. They can't be everywhere. And since the whole notion of the securities laws and the people in financial services is other people's money, how can we create a framework that's going to work since examiners can't be everywhere? Answer: firms need to be in a position to police themselves, have their own supervisory procedures, and if they're not reasonable, there's liability around it. And that's the way they set it up. So you think about this kind of mosaic where you have 11,000 investment advisors in the United States, maybe 4,500 broker-dealers, each with their own compliance programs, sort of taking care of things internally, so that you're actually, in a way, the eyes and ears of the investing public in terms of making sure, with management, that they're doing their job right and that things are right. So we have the same mission. So my suggestion in terms of thinking about dealing with regulators is, since you have a mission for investor protection, like they do, since you have a mission for the integrity of the markets, like they do, behave that way when you're talking to them. Behave that way. Don't treat them like a civil litigant. So there are a couple of practical things. One, you're going to see them again. If you have a scorched earth policy and then you're basically doing this to your regulator, that doesn't necessarily build productive long-term relationships. So you have to sort of think about that in the back of your mind. The second thing is that, look, I've been inside two government agencies, U.S. Attorney's Office and the SEC, and we're people too. We're people too, and in many respects, it's almost, I don't know if you guys, obviously, you probably don't do this at Harvard Law School, but when I was in high school, people would talk about people, right? This didn't happen to you guys? People would talk. People get reputations, and you know what? Those reputations get legs. And you don't want to have the reputation of being someone that is kind of playing fast and loose with this, frankly, incredible privilege of being able to provide sort of financial solutions and guidance to the American public. So net, while you can be firm in your views if you have a disagreement, always, always, always honor their mission. And the last one, obviously I didn't do this in any particular order, but I wanted to end on ethics and culture. While you in compliance, assuming you're doing this or overseeing it, can enable this, you can't drive this. This is a function of the values of the firm's leadership. This is a function of the quality of the firm's leadership. And it's not just this sort of hackneyed term of tone at the top. That's easy. People can make speeches and give videos and all that kind of stuff. Think about it in terms of like tone from the middle. I've heard stories where the compliance officer, a story from another firm where the compliance officer apparently had wanted to do some ethics training, and they created something called like a prefab meeting that they wanted management to give to their troops. And I guess to the chagrin of this particular manager, it turned out that the compliance officer's daughter was sort of interning in this group. And the head of the management head went, by the way, compliance said we should do this training, but let's not say we did. It was a fine firm. It just, sometimes the values aren't there. And it isn't just a question of the function of that person in charge, so it's also a function of, those that are sort of further down. So the only thing I can say there is, there are ways to do this. Some firms sort of do a lot of employee engagement surveys. You can sort of get a sense of business unit by business unit what their cultures are. And you could sort of use as leadership development opportunities feedback from these cultural exercises. But recognize the realities of human nature. Become a student of them. Learn behavioral ethics. Look, if you go back to, if any of you that took psychology in college, there's this notion of Maslow's hierarchy, right? You can't get to higher order thought in terms of things like values until you sort of are comfortable with surviving. So when you have issues where people feel like their survival's at stake, or they're not going to have money for their family, the incentives are very, very strong, regardless of the higher order values that they have, and you need to be conscious of this. And then, most importantly, for yourself, assess carefully, very carefully, whether the firm's culture is one you embrace. Because without good culture and values, everything I've told you today doesn't matter. It won't work. That's it. Questions?
So you talked a little bit about role clarity when you started. And you ended with ethics and culture and talking about getting along with regulators. So I'm curious, you're a lawyer, and there's a huge trend in large publicly traded corporations for the compliance department to be filled with lawyers. What type of role issues have you experienced, or do you think many of our students will experience in being lawyers and also compliance officers? And do you think that lawyers are better at being compliance officers than, dare I use the term, non-lawyers?
Great question. There's actually a couple of interesting facets to that. And frankly, the banking regulators have been a leader in terms of this first part. So there's some, first of all, a lawyer makes a great compliance officer. Because why? You need to know law, right? So that part is sort of clear. But you also need to develop, as I mentioned earlier, other skills that lawyers sometimes naturally don't have. Management, leadership, process excellence, how to run a business. So other people that can be good compliance officers sometimes might have different skill sets. Let's say someone who's been an auditor, someone that's been involved in operations. They may understand the process part, but they would need to learn the legal part. In terms of the sort of like the issue with compliance officers as lawyers, one of the things you have to think about, and I think the banking regulators do think about this, is when you're a lawyer, you have ethical duties to sort of act in your client's best interest. You have duties of confidentiality. You have everything that the ethical rules require. And I guess there's some schools of thought that question whether someone acting as a lawyer, whether it would be an inconsistency with a lawyer that might be in a position to want to kind of prepare their company for defense versus a compliance officer whose mission is a little bit different. As I mentioned earlier, you sort of have a similar mission to the regulator. You want to get things fixed. You want transparency. You want things taken care of. And sometimes it's in your interest to actually share that information with the regulator just to show that you've got it nailed down. So there's a question about whether there's sort of tension between those, because are you kind of, as a strict matter, would a lawyer just thinking about defense take the same steps that a lawyer acting as a compliance officer would? I can tell you that, and just maybe it's because of the firms I've been with, I've never had that happen, because at the end of the day, the firm's interest in its reputation and ongoing relationship seems to have carried the day. But that does come up, and I think that you've seen it. There's a little bit of a tendency to where compliance officers are less and less reporting into the legal department. They tend to report elsewhere, and I'm assuming, without knowing, that So those arguments and discussions are kind of a reason for that. Yep.
Going back to the deferred prosecution agreements
Uh-huh.
you're talking about, like the HSBC and all that, I know a lot of non-financial settlement terms were included in
Yep.
those prosecution agreements, like compliance monitors and time bonuses to, fulfilling compliance mandates and things like that. Do you think those are effective at instilling a culture of compliance, specifically the compliance monitor target?
I'm going to give you the answer that Lyndon Johnson hated so much. On the one hand, and on the other hand, he famously said he wished he only had one armed economist. I think at the end of the day, things don't necessarily translate into culture, but they could improve it, because if you have better habits and you begin to sort of take on things that maybe you didn't think about fully enough, that could end up getting you to a better place. So does it change the hearts and minds of someone who's otherwise evil? Probably not. Does it maybe educate someone and sort of bring them around? Perhaps. I do think that there's also an interesting sort of deterrent element to others suffering those kinds of situations, because having a compliance monitor is not perhaps the most effective and efficient way to do business. And so even if it's a pure profit maximization or pure competitive advantage issues, you want to avoid those outcomes. So putting them in either in your firm or in somebody else's may drive good behaviors. But in terms of changing their hearts, probably not. In terms of making them better managers and leaders, probably. So that's my two-handed answer. Yep.
So how do you see the pros and cons of being a general counsel in a corporation as compared to being the CEO or other managed positions in a corporation, especially like some career advice positions?
All right, so CEO versus general counsel.
Something like that.
Well, CEO is obviously a broader remit. I mean, you have to have a lot of skills, and you have to have a lot of ability to sort of manage and pull together different threads of information within a business. And you have to sort of deal with market realities. I think a good general counsel has a lot of sort of like the sensitivities that a good CEO would have, but they tend to be more giving advice that someone else will execute. It's just a question of in terms of a career choice, it's a question of, do you have a passion for actually running and leading yourself? Or do you see yourself as someone that can be that trusted counselor to help somebody else lead something? Yep.
You talked about relationship with the regulating authorities, and you talked about preventative measures. And I'm wondering, at the time of hiring a financial representative, there's fingerprinting going on. There's a background check with the federal and state authorities.
Mm-hmm.
Also, investors can actually look up the financial representative on the FINRA website
Yep.
to see if there was any disciplinary action.
Mm-hmm.
In your relationship as a compliance employee, when your relationship with these like SEC, FINRA, is there a way to leverage that? Is that like a full comprehensive view into this person's background, or is there a way to maybe delve deeper with FINRA as a compliance officer to say, I don't know?
All right, let me restate the question. So the question is in terms of getting information about a person.
Yeah.
Your relationship with the regulators, you're probably not going to get much more than what's in broker check, which is the thing you're talking about. Frankly, because broker check is a function of what a registered representative or someone tells FINRA through a form. If FINRA or the SEC has experience with a firm or a person through an examination, particularly with the SEC, examinations, and unless they have a formal order of investigation or an actual public enforcement action, that's all non-public. So, and so you're unlikely to sort of get extra color. If Chuck Senatore is a broker and you want to hire him, the local FINRA district office is going to say, oh, by the way, you have this stuff in broker check, but I think Chuck Senatore is a jerk. It's not going to happen that way. You do have ways of looking through the disclosures. They're pretty deep. I mean, in terms of, you'll see settlements, you'll see allegations in arbitrations, you'll see all sorts of stuff. Anytime they had a disciplinary, you'll see a lot of stuff, and you'll sort of make it able to make your own judgment. But in terms of getting their impression about it on top of that, no. Yep.
So, especially in the financial services industry, it seems a certain investment instruments and things you need a PhD in math to really understand. How, as a compliance officer, do you keep up with the technical expertise of the industry?
That's a great question. In fact, I'll amend it, because not only is it the products, but also the fact that there's a increasing reliance on technology. As businesses go forward at the speed of light, as you become global, you're managing large amounts of data. Just a regular, sort of like monk, Brother Abbott type, it's not going to work. So you're right. So increasingly, the obligation to supervise is based upon processes that are either captured in technology or captured in terms of some of the products you mentioned, algorithms and things like that. So how do you do it? First of all, there's actually some discussion that compliance people have had with the regulators in terms of what do you expect of me as a compliance person? Do you expect me to not only understand the rules and regulations, do I need to know programming? Do I need to know, what do I need to know here? The practical answer in my mind is going back to role clarity and sort of making clear who does what. So if you're in a firm, there are people whose skill sets are technology. Increasingly, you might be able to, if you're blessed with having be able to hire staff, you can bring people on staff that sort of know technology. And I think, compliance people or lawyers that sort of have that, it would be particularly valuable going forward. But at the end of the day, if you yourself don't have that capability, as long as someone who does is accountable, even if they're not in the compliance department, if they're in the business itself, because don't forget, the business has an obligation to execute what it needs to execute and to supervise what it does as a matter of law. And that does, not just in the securities business, basically anywhere. So if you're heavily reliant on technology, there's going to be somebody there that understands the space. And what I would recommend, if you're sort of in a position where you're looking at a compliance issue, to make sure that there's clear accountability that those people are basically either doing certain things, following certain processes, and you don't necessarily need, in the short run, to be a technology whiz to make sure that they're sort of dealing with basic controls in terms of testing and monitoring. Show me the report, show me what you're doing. Have you sort of matched your requirements to the outputs? You can have that conversation without being a technology master. Down the road, certainly people with those skills will be needed. Same thing with products. You have product people that kind of understand the math, but you should have processes within your firm to make sure that product, before you send it out for possible consumption by investing public, does what it's supposed to do, that the risks have been identified, that you're able to disclose those risks ahead of time, and make sure you're looking to ensure that you're not giving something to a client that's really not for them. It's not suitable. Yeah.
Compliance officer, if your firm that you serve has those international branch or with any international business, how much attention would you take to the international regulator, and how do you deal with the international regulator, especially if you don't have much knowledge about those laws of that jurisdiction?
Great question. So there are two ways. One, if you have a large enough organization where you actually have offices there, because sometimes a regulator can have a long arm, and even if you're not really there, if you touch an investor there, you may find yourself in a jurisdiction even without an office. But again, the principle is having people locally that understand the regulatory scheme, understand the regulator, and know it as part of their job and who they are, because I don't care how brilliant the head of compliance is, no one's going to be able to master the minutia of regulations in different parts of the world, right? You need to know the issues, and it's funny, the issues are actually very, very correlated in terms of different sort of securities regimes, in terms of the notions around investor protection. So if you're in a big firm, you can put people on the ground that sort of know those regulators. If you're not, sometimes you might need to either engage consultants that know the space or law firms that know the space that may have those relationships to be able to help you get through it. But it's one thing that you probably shouldn't do is try to figure it out yourself. It's kind of like what's that saying, that a lawyer that represents himself as a fool for a client? So, I mean, make sure you have people that have the skills involved. Anybody else?
Does Fidelity hire law school students directly out of school in the compliance department?
Rarely.
And why is that?
Experience.
So what type of experience should somebody that has a law degree that wants to get into compliance seek in order to make that a career option in the future?
Great question, because this is kind of in flux. Number one, learn about the space. I think certain schools are sort of offering programs that you sort of understand the space. I mean, I go to Chicago, we do it there. I know you've been involved, Michelle, and that kind of thing. So it's like learn as much as you can about the space too. Maybe look for internships. B, that may be a good way to sort of get into a firm and see it. C, some firms may. D, sometimes a way station with a consultant in terms of learning the compliance space. So if you're at a Big Four and they sort of counsel and do engagements for firms that deal with compliance, you begin to learn it that way. Or if you're actually working in a law firm and deal with regulatory issues that pertain to, in my case, the financial services industry, you'll begin to see those issues. Again, just in terms of the way the hiring model, and maybe it needs to be sort of rethought, but it's, we tend to bring in people with experience. It's not saying it never happens, but we just tend to. And there are other ways to get it if you're interested in the space.
Well, let's give Chuck a big